before I make my formal comments, I want to be sure that you have kind of a background of how we ended up where we are today with the ruling from the court. As you know, Act 1 was an initiated act that was placed on the ballot by the Family Council Action Committee and about 2,700 volunteers. Those people went out and gathered signatures on petitions. They gathered about 100,000 signatures, and that issue was placed on the ballot in November of 2008. And it passed by the voters, was passed by the voters in 2008 by 57% of the vote. I believe a little under 600,000 people voted for the measure in 2008. And of course, as soon as it passed, the ACLU filed a lawsuit to try to have the act declared unconstitutional. And it was, that case went before Judge Chris Piazza here in town, and he indeed did declare the act unconstitutional, but that was a lower court ruling. Now then it was appealed to the Arkansas Supreme Court, and they agreed with Judge Piazza, and they say the act is unconstitutional and it's struck down. So that's a little bit of background about that in case you may be new to trying to cover some of this. And of course, there's a lot more to it than that, but that's kind of a summary. Okay. And for the record, my name is Jerry Cox. That's Jerry-C-O-X, and I'm president of Family Council Action Committee. And the Action Committee is the part of our work that actually worked on the initiative and got the act passed and all that. So that's the more political branch of what we do. Okay, let me begin my formal comments. This is the worst decision ever rendered by the Arkansas Supreme Court. We said from the beginning that Act 1 was about child welfare, not adult rights. Well, it's still true. But today, the Arkansas Supreme Court put the rights of adults way ahead of the welfare of children. When I read the ruling from the Supreme Court, I realized that about 90% of that ruling focused on the rights of adults. And so it was almost as if children were a piece of property rather than human beings as I read this ruling, because they constantly talked about what adults get to do and what adult rights ought to be. And I wanted to just say, time out. What about the welfare of children? Don't we always write adoption and foster care law with the rights of children first? And that's the way it's always been up until today, when the Supreme Court issued this ruling and said the rights of children are secondary to the rights of adults to engage in private behavior. And I believe the court knew from the beginning how they wanted to rule. They just needed to find a route to get there. They needed to find some sort of legal justification for getting there. And so they had to take some crooked roads and a long way around to try to justify legally what they have done. But they will never be able to justify what they've done to the children of Arkansas. People might ask, did Family Council lose this case? Well, sure, the case is lost, but the big losers in this are every adopted and every foster child in the state of Arkansas today and for years to come. Because now the court has said to every one of those children that your right to be placed in a good, stable home where you can have a good chance of success must be secondary to the rights of adults and what they want and what they get to do. And that's the unfortunate part about this ruling. We had expected justice. Instead, the court gave us judicial tyranny. Our Arkansas Supreme Court has told the people of Arkansas that their vote doesn't matter. This law was passed by the people of Arkansas in a fair election where everything was done the way it was supposed to be. The ACLU tried to defeat this measure at the polls, and the people of Arkansas disagreed with them. And so then they turned around and took this to the courts and asked the court to overrule the will of the people. And 7 justices on the Arkansas Supreme Court have now overruled the wishes of the people of Arkansas as they express their view in a fair election. And that's a slap in the face to every person in Arkansas who votes. Now, some of you may say, where do we go from here? Well, first of all, the Arkansas Supreme Court is the highest court in Arkansas. So there really is nowhere else to go legally in Arkansas with this case. Some people have said, well, might there be an opportunity to go into federal court and take this into federal court? We're talking with our lawyers about that, but their general consensus is probably not. There's probably not enough grounds to take this to federal court. And so what's left really is to look at maybe look at a couple of things. One would be to bring this back not as an initiated act, but as a state constitutional amendment that would actually be written into the Arkansas Constitution. That would give it a higher level of standing, as far as the courts are concerned. So a constitutional amendment is a possibility. And then, of course, the other possibility is to work with the Arkansas legislature to try to get them to step up and pass some legislation that will protect the welfare of children. But, of course, at this time, we're still looking at options. We fully expected the court to affirm the will of the people and rule in favor of Act 1. And so we're both surprised and very disappointed in what the court has done today. Not so much because it erases all the hard work that we did, but because of what it does to adoptive and foster children here in the state of Arkansas. So that concludes my formal remarks. I'll be glad to try to answer any questions that you may have.
Don't you have 10 days to ask for a reconsideration? If so, you can do that.
Well, we could ask the court to reconsider, but considering the fact that the decision against Act 1 was unanimous, the likelihood of the court changing its mind, I think, would be very slim.
So you don't plan to do that?
Not at this time. We don't have any plans to do that at this time. But that's a good question. Yes, sir?
The original initiated act was sought after the court ruled unconstitutional a state policy concerning this.
Right.
How is the initiated act proposal different from that state policy?
That, now are you talking about the policy that the health department had, where they overturned that? Is that what you're talking about? Yes. It's my understanding that the Department of Human Services had a long-standing policy for years where they did not place foster children in homes where people were cohabiting. I think the term they used, though, was kind of an unusual term. I think they talked about transient boarders or something like that. But it amounted to the fact that their policy did what Act 1 was asking for. Now, Act 1 did carry that same policy into a broader area, and it addressed adoptions as well. So my understanding, the way Act 1 was different from the health department policy they had for years was that it applied that same policy to adoptions as well as foster care. But that's an important thing to point out is that the Department of Human Services had this policy in their rules and regs for years and years. And right before Act 1 was on the ballot, they reversed that policy and said, no, we've decided we are going to put foster children in cohabiting homes after all. And so I think a lot of people around the state, they looked at that and said, well, we think that was a pretty good policy and it ought to be put into the law if they're not going to follow it there at DHS. So I think that probably helped Act 1 actually get passed.
Didn't the judge rule state policy unconstitutional?
Not that I'm aware of, Rob, but we may be thinking about two different things. See, you have to understand, those of you who are maybe new to this has been debated since, I believe, 1997. And so there have been debates at the Department of Human Services. There have been all kinds of things that have gone on, legislation attempted, and so forth, over the years since 1997 when this issue first kind of bubbled up to the surface. So I've slept since then. You may be remembering something I don't remember. Other questions?
Gary, you talk about the will of the voters versus this court decision.
Correct.
But you can't just legislate anything you want. I mean, isn't that why we have courts to determine if things are constitutional or not?
Yes, that is correct. And but here's the fine line that every court has to walk. Are they the interpreters of the law, or are they the creators of policy? And see, I would argue that the people have a right to make just laws, and to say that children in foster and adoptive care shouldn't be placed in certain homes, that doesn't rise to the level of passing a law saying that you can't have free speech or you can't have freedom of religion, because states always regulate adoption and foster care. And so the court, in my opinion, stepped way over the line and became a policy-making body rather than a judicial body in this particular ruling. I'll give you an example. Right now, if you smoke cigarettes, you can't be a foster parent in the state of Arkansas. A lot of people don't know that. But the legislature passed a law saying if you have a smoker in the home, you can't have to be a foster parent because of the dangers of secondhand smoke. State law mandates how many square feet you have to have in your house in order to be a foster parent. It says you have to have a window in the bedroom of the foster child. I guess to keep people from putting foster kids in closets or whatever. But there's a whole litany of rules, not rules and regs, but laws that regulate how foster care will be done here in Arkansas. And so this was added to that list. And the court just came back and just obliterated that. And it makes me wonder how vulnerable how vulnerable our other laws may be to the court coming in and just saying, you can't have any laws regarding adoption and foster care. Every case has to be decided by a social worker on a case-by-case basis. And that puts the social workers in a real bind because then they've got to make all the decisions. Other questions? Yes, sir.
You talked about the rights of children.
Yes, sir.
So wasn't your argument that children don't have rights to be adopted or fostered? Wasn't that y'all's position in the case?
I don't recall ever, no, I would say no. That our position has always been that every child in Arkansas has a right to be placed in a good home, especially if the state takes that child out of the home he or she is in. And that's what a lot of these kids are. Their kids have been taken into state custody. So if the state reaches over here into a home where a child is and says, we can do better for you than that, you have a right to a better home than this, then the state reaches over there and pulls that child out of that undesirable home and says, let us do better for you. And so the state at that point has a huge obligation to treat those children the way they need to be treated and not treat them the way the court has viewed them, like pieces of property that just sort of get passed around based on what some adult thinks his or her right ought to be. That's never been the way we write adoption and foster care law. We always write it with kids' rights at the forefront, and then the rights of adults come second. Other questions or comments? Yes, ma'am.
If you try to get a constitutional amendment passed, would it have the same scope as Act 1, as far as involving unmarried section?
And obviously that's a good question, and obviously I don't know the answer because what we might do with a constitutional amendment, that would take weeks and months of discussion and trying to figure out what would be the appropriate thing to do. So doing something like that would probably be months away if we did decide to do something like that. So it's not like I have a constitutional amendment ready to file tomorrow. It's something we'd have to really think a lot about before we jump into the middle of that. Because it's hard work. It's really hard work getting the people to change the Constitution. Okay, any other comments?
Well, the other thing they also addressed is they accused this of actually being an attack on homosexuals.
Right.
In Arkansas.
Right.
Is that right? Is that why y'all did this?
No. We said from the very beginning that this was primarily about child welfare. And I think if you go back and you look at everything we've said about this issue, it was about what's best for children. And quite frankly, what we discovered is that the most dangerous place for children is actually in heterosexual cohabiting homes. That's the most dangerous place because of live-in boyfriends, usually, preying on a woman's children. And so you start with that being the most dangerous, and you kind of work your way down. But everybody knows that it's been proven with every study ever done that the gold standard really is a married home with a stable mom and dad. That's been true for 5,000 years of human history. There are probably thousands of studies out there that would back that up, that having a stable mom and dad and having a kid raised by them is a gold standard. And that's what this act pointed toward. It turned our state in that direction rather than in some other direction that's going to lead us out here into a place where children are not going to be cared for maybe as well as they could be.
But does this ruling necessarily change existing state policy, which is to take things on a case-by-case basis? I mean, they said in oral arguments, there's the preference, even if this law is overturned, is to still not put kids in cohabiting.
And I would, David, I would hope that that's going to always be the case. But see, what this law did, it provided guidance for the social workers as well. See, if a person's out here being a social worker and they're trying to figure out, where do I put this child? Is it just left totally up to their arbitrary feeling of how, what side of the bed they woke up on that day as to where they put the child? This law provided some really good guidance for those individuals that work for DHS so that they wouldn't have to sit and scratch their head and figure out, well, what am I going to do? Well, they can fall back on the will of the people as expressed in this law and say, well, whether I agree with it or not, the people of Arkansas have spoken on this issue. And what's sad is the people spoke loud and clear, and the court silenced that voice. And that's maybe the larger tragedy today, is the fact that the court did this.
What about the argument that this will allow more kids to be adopted or foster care?
Well, Roger, that's a great question, about won't this allow more kids to be adopted? Let me kind of talk about this in a little bit different way. If our goal was to just get them adopted or just get them placed in foster homes, then we wouldn't have any rules or regs. We'd let smokers and drug addicts and criminals and people that don't need it, we'd just treat children like puppies and say, if you want a child, just drop by and pick one up and take it home. But we don't do that. We have restrictions for good reasons. They're not just there just for fun. They're there to protect the welfare of these children, because most of these kids had a home somewhere. May not have been a very good one, may have been an abusive home, may have been an awful home, but they had a home somewhere. They weren't just walking up and down the street with no parents. What we're saying to them is, we can do you one better if you'll let the state do this for you. And so once the state says that, then the state has obligations to meet pretty high standards. Because think about who's been mistreated the most. It really is these adoptive and foster kids. They've been neglected, they've been abused, and of all the kids out there, they probably need a real stable home, a really stable home, about as bad as anybody, because they're already injured and they're already handicapped in some way. So why not put them in the very best home possible, rather than settling for whatever we might be able to get?
Do you still disagree, Jerry, that this impinges on what the court ruling says is the fundamental right of privacy in the bedroom, basically?
That's what they were saying. And to me, they had to stretch a long way to make that argument. But as I heard some of the arguments at the court, I thought, they've already got their minds made up about how they want to rule. They're just trying to find a way to get there legally. And that's what I believe. And that's what it appeared to me, is that that's what the court was trying to do.
You weren't really that surprised at the oral arguments?
I felt that, I thought it would be a 4-3 decision. I just didn't know which side of the 4 or 3 we were going to be on. I was very surprised and very disappointed that it was unanimous against Act 1. That was the greatest surprise, is how one-sided the ruling actually turned out to be. And I think that shows how out of step the court is with the people. Because 57% of the people said, this is a great law, we want it. And yet, every person on the Supreme Court went the other way. That should tell you something about where the court stands in relation to the rest of the people here in Arkansas.